Not one, but two judges have now struck out at this state law, and interestingly enough, for related but very different reasons. Some of the issues that we're talking about: are you guilty until proven innocent? Are you guilty if the police chief says that you're guilty? Because after all, they arrested you, right? What happened? What's going on here? What does it all mean? Guys, let's get into it. All right, so we have two related cases to go through, both from just the last few weeks. First one we're talking about came out of a federal district court. The state we are in, the People's Republic of Massachusetts. So here we are. So the case is dealing with the Holyoke police chief, David Pratt's denial of a license to carry permit application that was submitted by Mr. Randy Westbrook. Mr. Westbrook. So the case is Westbrook versus Pratt. Now, the issue here goes back to the June 22nd, 2022. That's the Bruen U.S. Supreme Court decision. Yes, we have another Bruen case here. Now, recall that Bruen did a number of different things. It set what the legal tests and standards are when we are to evaluate a government's regulation to determine, hey, this is how we call ball or strike, fair or foul. This is how we figure out whether or not something is constitutional or not. And Bruen laid out the framework for basically a history and tradition test that we've covered many times here before. We're not going to cover again right now. Now, the other thing that Bruen's talking about, and both of them come up here, deals with license to issue standards. Specifically, we're talking may issue versus shall issue. And Bruen said, nope, we are now a shall issue country. And the second thing that Bruen talked about was the fact that you have to have objective standards. We can't just have subjective, wishy-washy standards, which effectively creates a may issue paradigm. So what are we talking about when we're talking about that? Well, let's go ask Mr. Westbrook, because Mr. Westbrook was basically denied under a very wishy-washy may issue effective standard. I'm going to read part of the statute here. The licensing authority or the colonel, apparently that's the individual who is in part responsible for issuing, denying licenses, shall issue if it appears that the applicant is neither a prohibited person, okay, nor determined to be unsuitable to be issued a license as set forth in this section, provided that upon initial application for a license to carry firearms, the licensing authority shall conduct a personal interview with the applicant. Okay, yada, yada, yada. So you cannot be a prohibited possessor. That's very standard. And if that's all that we were talking about here, we wouldn't be here. We're talking about the fact that if you are unsuitable, okay, so what does it mean to be unsuitable? Because we're not talking about being a prohibited possessor. So for instance, we're not talking about somebody who's a violent felon or something like that, right? Or has some sort of qualifying domestic abuse injunction, although that's also, of course, subject of a current U.S. Supreme Court case right now. So we'll see where that all goes. But for the time being, we're not talking about those canonical prohibited possessor categories. So what is the definition of being unsuitable? Well, the statute provides once more for Massachusetts, quote, a determination of unsuitability shall be based on reliable, articulable, and credible information that the applicant or licensee has exhibited or engaged in behavior that suggests that, if issued a license, the applicant or licensee may create a risk to public safety or a risk of danger to self or others. End quote. Okay, so you're unsuitable if basically the police chief or whoever's the reviewing authority thinks that, look, you may create a risk and that this is somehow based on reliable, articulable, and credible information with, as I saw, no particular parameters put around what's the definition of risk as far as being a danger to self or others. What does it mean to have articulable or credible information? So it's pretty wishy-washy, because what constitutes a risk to one police chief may have no bearing or resemblance to what it means to another one. What constitutes credible information may have one particular set of meanings to this particular police chief, but something entirely different to the next one. So even though the statute says that, hey, if you meet this criteria, it shall issue, the fact that the criteria is wishy-washy effectively invokes in no small part, a may issue paradigm on subjective criteria. And that's the basis of this very first judge, the federal district court judge. That's the federal trial court when we're talking about district courts. Recall district courts, circuit courts, U.S. Supreme Court. Those are the three layers that we're talking about, unless we're talking about patent courts and all this other kind of stuff. But for where we are concerned with this channel, for the most part, we're talking district, circuit, U.S. Supreme Court as the three most common layers to the federal court system that we're concerned about. Guys, we have a fun quote of the day coming up at the end of this video, and my question is going to be related to that. The gist to it is going to be, what is it about people being able to carry firearms responsibly in a trained, healthy fashion, backed by statistics, tradition, and history that irritates the gun grabbers? Let me know in the comment field below. And of course, don't forget to hit that like button, all the YouTube stuff. Now back to the video. This denial is reviewable, which of course is in no small part how we got to where we are right now. The statute does read, the determination of unsuitability shall be subject to judicial review under said paragraph sub F. What's this credible information we're talking about here? Well, I don't exactly know, but it would seem like back around about 2010, Mr. Westbrook had been arrested and charged with a crime that he was ultimately not found guilty of after the charges were dropped. Sort of. Mr. Westbrook accepted what is charmingly called a continuance without a finding, or CWOF, continuance without a finding, something that I as a Wisconsin attorney has never seen or heard of before, but I'm inferring that this is something kind of common out there on the East Coast, at least in Massachusetts, on the charges of what I believe are aggravated assault and battery, under which Mr. Westbrook acknowledged that he had committed the charged offense. However, there was no finding of guilt by the presiding judge. So you can kind of argue that both ways. You can kind of see where the police chief is coming out of it, because he said, look, you effectively did this and you acknowledged that. However, on the other hand, we do have this finding of guilt, and that is kind of an important step, and we never know how things get negotiated out and pled out in court for various reasons. Maybe this was a halfway in between point. Maybe there was shaky evidence. Maybe there's any number of different things, and this was basically the deal that was arrived at between the parties to resolve the case and get it over with. Speaking as an ex-state prosecuting criminal defense attorney, you see these sorts of things happen a lot. That's the reason why at the end of the day, the question is, did the ball cross the goal line? Was there a finding of guilt or not? Now, even though there was indisputably no finding of guilt, nonetheless, the police chief seemingly have used that as part of their decision here, and it was also brought up as part of the pleadings to this case, along with another non-criminal forfeiture issue that involves some drugs, as I understand it. Ultimately, though, the federal judge didn't really care about this history, because the federal judge was focused on the bigger issue at hand for them, which was the problems with the law. The judge pointed out that under the Bruen decision, a licensing authority must justify its regulation of a constitutional right, such as allowing someone or recognizing someone's right to go forth and to be armed for self-defense purposes, as one example, by showing that the laws and regulations on that right, that burden that right, are consistent with the nation's historical tradition of firearm regulation. Now, in a 14-page decision linked in the description box below, though it is behind a paywall, I'm sorry, I can't fix that, the judge wrote in part, quote, "Any law that restrains this right must be narrow and objective and must provide definite standards that limit the discretion to be exercised by the licensing authority." And this is again about G.L.c. 140, section 131. That's the Massachusetts law we're talking about. Now, that law is linked in the description box below. The judge went on when talking about that particular statute. Quote, "The law is generally consistent with the historic tradition of denying firearms to dangerous persons, but its standard for determining whether an applicant is dangerous is not narrow and objective. It impairs an individual's right to bear arms for self-defense based on a determination that his or her past behavior suggests the individual may be dangerous if armed, giving the licensing authority an impermissible amount of discretion," end quote. That's case number one. So again, the judge is focused in case number one on this wishy-washy may issue. huge gulf of discretion and seemingly almost boundless authority given to the reviewing police chiefs and these reviewing authorities on who and when and why and how they can issue licenses. Let's talk about the second case. Now, the second case comes out of the Fall River District Court, Judge Kevin Finnerty. Now, this happened on May 14th. So again, these two decisions, though in unrelated cases, came within days and just a couple weeks of each other. Now, this is a very similar case and I apologize if I mispronounce this, I believe it's Echeverria v. Cullen. Now, this case was initially seeking a judicial review from the denial, which we talked about as a process above, for the firearm identification card, sometimes called a FID, and later involved a suspension of the license to carry. Now, in granting this particular petition, the judge in the second case said that he agreed that, quote, the discretionary suspension or grant of a constitutionally guaranteed right to which our case law requires courts to defer is inconsistent with the Bruen holding, end quote. So what does that mean in English? Well, what the judge is basically saying is, look, the legislature is forcing the courts to give these oftentimes unelected individuals, such as chiefs of police and so forth, or whoever it is that's responsible for issuing these licenses, an enormous amount of deference on when and how they are going to be reviewing these decisions. And basically this deference, these guaranteed rights are conditioned upon because, remember, if the police chief says no, if the government says no, if the courts are required to give huge deference to what those authorities just said, this is all burdening the right. And that's just too much, is what the second court focused on. So the second court focused on the enormous deference that the reviewing judges are required to give these licensing agents. Whereas in the first case, that's the Westbrook case, the judge focused on the lack of any objective meaning to the words, who is unsuitable? And you know what? They're both right. Neither of these judges are wrong, even though they're talking about the same case and reaching more or less the same conclusions, but via totally different roads and trajectories. That sometimes is something that you see when you deal with bad laws. And by the way, if you're wondering what the government's response was, well, the president of Massachusetts Municipal Lawyers Association did write in a comment that I found in a news article, quote, police chiefs want to maintain the discretion that they currently have, end quote. And water is wet, right? Because that comes as no surprise whatsoever. And that is 0% intended as an anti-police comment. It is 100% intended as an anti-gun grabber comment. What does this all mean? Well, there's really limited to no precedential value because we're talking about individual cases and individual outcomes, not somebody who is challenging the law per se for being unconstitutional. Maybe someone out there in one of those great groups is interested in taking a crack at that. But at the end of the day, here we are finding ourselves once more in 2024 talking about may issue versus shall issue and objective versus subjective standards. And another one, hopefully, will be biting the dust soon. We've got 2 more bricks in the wall taking down the Massachusetts law. We appreciate you sticking around this long. Let's check out our quote of the day. This one comes from one of my favorites, psychologist Carl Jung, who wrote, quote, everything that irritates us about others can lead us to an understanding of ourselves, end quote. I wonder what that would mean for victim disarmament enthusiasts. What is it that irritates people about being able to defend themselves against a violent attacker? What would that say? I wonder. Post up your comments and responses about what you think that might mean in the comment box below. I look forward to seeing that conversation. Thanks for sticking around. And as always, I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.